Good afternoon. I'm Stacy Johnson, webinar host at NAMIC, and I would like to welcome you to today's webinar, Reducing Litigation Losses with Technology. We want to give a warm welcome to all of you that are joining us today. Before we dive into the main content, let's quickly go over some important details. Today's webinar will last approximately 60 minutes. You can find a copy of the presentation by clicking on the handout section located on the right side of your screen. Should you encounter any technical difficulties during this webinar, please don't hesitate to use the live support option found in the upper right corner of your screen, and a member of the NAMIC team will be there to assist you promptly. In the event that our presenters face any technical challenges, we will remain online until the connection is restored and the webinar can proceed. We appreciate your patience and encourage you to stay connected with us as well. Please take notice that we do operate under our antitrust statement, which can be found outlined on this slide. The antitrust policy will guide this conversation, and we kindly request that you follow its guidelines when submitting questions to our presenters. Along those same lines, our presenters are sharing their experience and opinions, which should not be construed as specific advice. We love participation, and we encourage you to participate in today's webinar by asking questions. If you would like to ask a question, simply submit it through the live Q&A feature on the right side of your screen. Our presenters will answer as many questions as possible throughout the presentation. We would like to take a moment to thank our 2024 webinar series corporate sponsor, Holborn, for their generous support of this year's NAMIC webinar series. We'd also like to thank Butler, Wymuller, Katz, Craig, LLP for their support of the Claims webinar series. At this time, we would like to welcome our presenters, Rena Gehman and Jay Holder-Smith. Thank you both for joining us today. Jay, as an opener to today's subject, can you share some of the industry trends that are impacting social inflation and the mega verdicts you're witnessing in Georgia and across the country?
Absolutely, Stacy, and thank you for having me today. I'd like to first of all say that if I had the magic answer to why we have so many nuclear verdicts in this day and age, I wouldn't be here today. I would be in Tahiti at my private compound if I had the magic answer to that question. But I will share some things that I think are definitely impacting the size of jury verdicts. I think if you get to a bedrock issue and, maybe relevant considering the time of year we're in, election year, I think the disparity of wealth in this country, number one, is a driver. Definitely, when I started in the 1990s, certainly there were a lot of wealthy, successful people then, but the size of the ultra wealthy just was not what it is today. And I think the awareness of that, and then what we get, not just in election season, but year round in the media, and I'm gonna come to that in a minute. But I just think that awareness and, the erosion of the middle class. We used to, on juries in Georgia, you would have predominantly middle class people. That's not necessarily the case anymore. And I think that wealth disparity, if you want to just drive it down to the lowest common denominator, I think that's a big driver of the verdicts. Couple that with the rise of communication in this country. I'm old enough, sadly, to remember when there were 3 networks, and that's what you got. And now, of course, on cable TV or whether you're streaming, you have hundreds of different media outlets just through television, plus the internet, plus social media. There is this proliferation of information, which is generally a good thing. But now so many, it used to be if you didn't watch Robin Leach, I'm definitely telling on myself how old I am. If you didn't watch Robin Leach, you would have no clue what the ultra wealthy in this country are doing. And now, we could all sign off and go to about 5 or 6 different sources to see, you know, what Bill Gates is doing today and how much money he's spending and how much money he has. So I think if you couple the wealth gap in this country with all of the different forms of communication, that those two things, the intersection of those two things, in my mind at least, are definitely driving large jury verdicts. I've been in some focus groups. I've been in actual jury selection. And now I can tell you in Georgia, one of the first questions asked by plaintiffs' attorneys during voir dire, one of the very first ones, is, do you think corporate CEOs make too much money? And that's coming out of the gate. So there's no question. I'm not the only person who feels this way. It's definitely the other side feels that way. And just to be blunt, they're doing a good job of taking advantage of it. Third thing is attorney advertising. And Stacey, we talked a little bit about this in our prep session. You know, up until basically from 1066, when William the Conqueror invaded England, through the late 1970s, if you go through Anglo-American common law jurisprudence, it was not only prohibited for attorneys to advertise, but actually in England, it was a crime. It's called barratry. That if an attorney tried to solicit business, that attorney, not only would they get kicked out of the bar, lose their profession, they could potentially go to jail. And of course, in the late 1970s, the U.S. Supreme Court, rejecting literally 1,000 years of jurisprudence in the Anglo-American system, said, "Whoop, wait a minute. The First Amendment says attorneys can advertise." Now, in the beginning, and I can remember when I was in college, a law firm that's still around, it's now Motley and Associates, but at the time it's Gilbert and Motley. That's the first TV advertisement for an attorney I'd ever seen. It was a joke. It was comical. It made attorneys look bad. And then even 20, 30 years ago, most of the attorney advertisements centered around, I'm going to get you money. Okay. I'm going to get you some money. That was the theme. And of course, Morgan & Morgan is no stranger to anybody on today's call. I don't like them. Nobody does. But the fact of the matter is, they've taken that, get in a wreck and I'll get you a check, which makes the legal profession look terrible. Now it's the people versus the powerful. If you look at attorney advertisements now, it's going to mention money, obviously, but it's going to be, we represent the little person against whatever industry, whether it's insurance, hospitals, trucking companies, you name it. It's the people versus the powerful. So we went from, I can get you a check, to now it's people versus the powerful. And sadly, I think that's had an influence. So those would be the trends, I would say. And then, of course, for the folks on today's webinar who are from Georgia, you probably know that in 2010, there was a dramatic alteration of the method that jurors are pulled to put in the pool. And now, instead of going from strictly from registered voter rolls, now we go pulling from driver's license rolls, public assistance rolls, coupled with if you're over 70, you can get out of jury service automatically. You can decline jury service if you're 70 or older. So we just took this huge group of baby boomer conservative jurors out of the pool, and we brought a whole new group into the pool that never served in juries before. So for a Georgia specific answer, I think that would be definitely part of the puzzle.
Okay, thank you for answering that. As we focus on attorney demand letters, Rena, can you tell me what type of tactics are being embedded into the attorney demand letters that are becoming more prevalent and problematic?
Well, lots and lots, actually. Demands often have contradictory conditions in them. For instance, in one part of the demand, it might say you have to issue the payment and send along with the acceptance within 15 days of receiving it. And in another part of the demand, it may tell you that you have to have the payment there on the 15th day. And of course, this could present a problem depending on when that 15th day fell. I know that we had a situation where we had to actually use a courier one time to deliver, to make sure it was delivered on the 15th day. And in fact, Jay had a case with another carrier where the 15th day fell on the 4th of July and their office was closed, and that presented an obvious problem. Problems with who is going to be released in a settlement demand. Sometimes they will offer to release your named insured, but no offer to release the driver. Issues with demands not having complete medical bills or records. And in some cases, you're not even allowed to call the attorney to tell them that the information is missing. Everything has to be in written communication. You know, in previous years and handling claims for 30 years, you knew attorneys by name and you could just call them up and talk to them about their demand or what was missing or what you needed and negotiate. But those days are over. You can't do that now in most cases. There's problems with methods of acceptance. In some cases, it'll tell you that you have to accept only by fax, or it'll tell you only by email. And then the information may be missing on exactly who you need to contact altogether. There's issues about how the check should be issued, and it has to be issued exactly in a mirror image of the way they write it in the demand. You can't miss a comma. We know that from some recent cases, that there are issues with tons of issues like that, that the check can't even have any description on it, meaning it can't even have your insured's name on the check anywhere. It can't have claim numbers. It can't have any restrictions, even bank restrictions, such as, you know, a restriction that the check is only good for 180 days. That presents an issue when you have to obtain a cashier's check because your check can't have any descriptions on it. So those are some of the main things that I'm seeing that are, you know, problematic in time demands these days.
Jay, can you share some of the mega verdicts that you've seen as a result of some of these tactics?
I can. And so what typically happens, kind of follow up on what Rena mentioned. So at least in Georgia, and by the way, there's a publication that has put Georgia as the #1 tort hellhole in the country, I think 3 years running. And I can tell you that I can't speak for what happens in other states, but I think Rena and I can definitely speak to what's happening in Georgia, and that's certainly true. And so basically, Stacy, what the plan is you've got a catastrophic injury, whether it's a death or someone's paralyzed, traumatic brain injury, that type of situation, but you don't have a corporate defendant with, you know, millions and millions and millions of umbrella coverage. You've just got an average, you know, Georgia driver with minimum limits of 2550 or 5100 or if you're lucky 100 300. So the whole concept behind these demands is we don't want that money. What we want to do, the plaintiff's bar, is we want to create umbrella coverage with no policy limit. The policy limit would be the surplus of the insurance company who's the target. So what you do is you do the demands. You write a demand like Rena mentioned, and it's based upon. And this is not something, because, you know, let's face it, it started in Georgia with a case where the attorney put a 10-day time limit on the demand and the insurer attempted to accept on the 12th day. Well, a time deadline is a pain, okay? None of us like them, but it's something that's easy to understand. Well, that is morphed over time. Guess what? Insurance companies can have calendars. So you can train claim representatives to calendar a deadline and make sure you meet it. Won't, you know, mistakes happen, but that's a condition that can be met with high frequency. So you take that case, which is back in the early 1990s, and it morphs. I mean, I related to a bacteria. Okay. The antibiotic kills the bacteria, but there's like 5% that live. Okay. And so next time you try to use the antibiotic, it's that 5% and the antibiotic doesn't work. And so the demands are constantly morphing. As Rena mentioned, what I call the 4.0 demand, because it's about the fourth iteration. What some very, very smart attorneys, you've got to give them credit. You've got to give them credit. Some very smart attorneys have done is you take these catastrophic cases. I call it the evil triumvirate, which is catastrophic damages, low policy limits, and clear liability. That's the triumvirate. That's what they're looking for. So then we get these nuclear demands, not a nuclear verdict, but it's a nuclear demand, because I can assure you that demand can blow up in your face. The most recently, they have taken the claim checks that I can speak to Georgia. I bet it's the same all over the country that insurers use. Things like on the back of it says all payees must endorse. On the front of it, it has the claim number, data loss, and named insured. It has all this information on the check that arguably it doesn't have to be on there. You know, the personal check that all of us write, if to the extent anybody even uses checks anymore. But, you know, the check that my wife and I have in our bank account, it doesn't have any of that. It doesn't have any of that. Doesn't have void after 180 days. So they seize upon that and they just put in fine print, not in fine print. It's not in fine print, but it's buried in a 10-page demand. The method of payment cannot have any restrictions, descriptions, blah, blah, blah. So, okay, no problem. And you send the check, okay, you got an impermissible restriction, 180 days, an impermissible restriction. It says all payees must endorse. It's an impermissible description. Oh, you put the claim number, data loss, and name insured. You don't need to put that on a check. That's the type of thing. So it's those demands that then lead to nuclear verdicts. And maybe one thing, and actually another lawyer, I came up with this, not me, but I think it's absolutely true. One reason we're seeing more nuclear verdicts is we're seeing more catastrophic cases tried. Why? Who wants to try a catastrophic case on our side of the V? Why? Because it's these setup demands. So the plaintiff's bar is sending these nuclear demands knowing that there's a good shot somewhere down the line, whether it's a claim rep not getting help from management and management not getting help to put in a plug for attorneys, not getting help from outside counsel, but somebody's going at it alone. And they don't, I'll come back to the mirror image in a minute, but instead of accepting, which is what they intend to do, they make an unintentional counteroffer. Oh, that's negligent or bad faith claim handling. And now we're going to trial. And so I think to add to the first question, why are we seeing more nuclear verdicts, at least in Georgia? I can tell you why. Because we're seeing more nuclear cases tried, and it's cases that can't be settled unless you come out of pocket on a tremendous amount of extra contractual money before there's ever an excess verdict. And I think all of this go, you know, the time demand that Rena and I have discussed, and by the way, you heard Rena say the mirror image rule. That's a common law doctrine that I think is pretty much in every state. We got taught that in law school probably about the second or third week, that if I said, Rena, I'm willing to sell you 100 widgets for $100 each, and Rena sent me a letter back saying, Jay, I accept your offer, but you're going to have to put a warranty on those widgets. Okay, that'd be a counter offer because I didn't offer a warranty. That's the mirror image rule. And it's really a consumer protection or a business protection. That way I don't get stuck with a warranty, because maybe I would have said, well, I'll do it, but it's going to be $125 a widget, not 100. So it's a protection for the unwary. That shield has been turned into a sword. Now it's a tactic to use to, quote unquote, set up the insurer. You don't accept everything as a mirror image. Now it's a counter offer. The offer is dead, and now you've exposed your insured to millions and millions and millions and millions of dollars of excess exposure. And so those cases get tried. They're unwinnable. they're unwinnable. Some recent verdicts in Georgia going back to 2019, 33 million. And by the way, none of these cases are corporate defendants. Okay, these are just regular folks who had a bad day and, you know, got into an accident, were negligent and hurt, or in some cases their negligence resulted in the death of somebody. 33 million in 2019. That kind of set everything off. Most recently, in the past 18 months in metropolitan Atlanta, 60 million, 80 million wrongful death cases in metropolitan Atlanta. No corporate defendant, just an individual defendant. 60, 80. A hospital just a couple of months ago up in rural North Georgia, a hospital, 100 million on a double amputee. So it used to be, we used to think a wrongful death case is a big one being $1 million. Now a big one's $50 million. There has been that much inflation from the 1990s to today.
Thank you, Jay. Rena, can you additionally share some of the mega verdicts that you've seen a result of some of the tactics that you were referring to earlier?
Well, I'm very lucky because our company's never had a verdict like that. We've never had a verdict anywhere close to that, thank goodness. But I've obviously heard of many carriers having huge verdicts like that over the years. The largest verdict that I can think about in recent history, and it is a corporate defendant, but it was here in Georgia, in Gwinnett County, was $1.7 billion against Ford for a defect in their Ford trucks that resulted in a double fatality. That's the largest verdict that I can think of myself. There's not been a verdict yet on this case, but there is a case currently in Clark County that, and this goes back to our discussion on time limit demands. A carrier attempted to accept a time limit demand, and afterwards the attorney said, no, you made a counteroffer. And some of the reasons that they said it was a counteroffer were for there was a condition in the demand that the check had to be delivered on the 15th day. They delivered it with the acceptance, which was prior to 15 days. They left a comma out of the name of the payee in the attorney's name. They left out a comma. After accepting it, the carrier tried to file a motion to enforce, and the trial court granted it, but the Court of Appeals has reversed that decision. So that has not went to trial yet. That's a Pierce versus Banks case, and I do anticipate that there will be a huge, huge verdict on that case. Obviously, Jay has more insight on these verdicts than I do because that's what he does. He handles EC claims, and luckily we have not had that here. So I would have to defer to him on the mega verdicts.
They're scary. I would say now when I do, pretrial reports on a wrongful death case, especially if it's in metropolitan Atlanta, my customary range, if it's 100% fault on the defendant with no aggravating, no punitive damage, no anything like that, then I'm saying $20 to $50 million. And those are numbers nobody had ever heard of. Honestly, prior to 2010, nobody ever heard of that. No one had ever heard of that. And unfortunately, and now this is a Georgia specific problem, and I don't know if it is applicable in other states. We have a Georgia Supreme Court case, Junior is one of the names, that has held that a plaintiff may recover double attorney's fees. They may get it under Georgia's offer of settlement or offer of judgment statute, which is 9/11/68. You can get it there, and you can also get it for under Georgia's stubborn litigiousness statute. And in that particular case, there had been an offer of judgment that was the threshold for attorney's fees was exceeded, and the jury also made a finding of stubborn litigiousness on behalf of the defendant, and that resulted, according to the Georgia Supreme Court, said that the plaintiff could get double attorney's fees because they were two different code sections, and there was nothing in either code section that restricted the recovery if you recovered attorney's fees under another code section. It dumbfounded, I think, a lot, or I think most everybody, because Georgia also has a non-duplication of damages, just general common law rule. You can't recover your same damages twice, except for attorney's fees. That now has really opened the floodgates. And so, in pretrial reports, we have to go through that. Well, if it's 50 million, then it could be 90. Well, wait a minute, how does 50 equal 90? Well, if we get hit for stubborn litigiousness, and think about it, think about the cases we're talking about, they're all clear liability. So if you, and a lot of them, the defendant has got vehicular homicide charges pending, which means you can't admit fault, because if you did, then the state of Georgia could use the answer filed by the lawyer to prosecute the person, which would be horrible if you were the attorney who filed that answer. Stubborn litigiousness is in all of these cases, whether it's, we think that's valid or not, it's there. So 50 becomes 90, because if there's a 9/11/68 demand made that's going to be way above the policy limits. It's going to be way above the policy limits, but probably way less than what the jury's going to award. So that's triggered, that's 40%. And then if a jury finds stubborn litigiousness, then that's another 40%. So it's 50 plus 20 plus 20 equals 90. And I call it I refer to it as the attorney's fees parlay, because I just cannot, it sounds like something you do in Las Vegas and usually lose, right? That's the whole thing with the parlay bet.
Sure.
Those gamblers out there on today's call, it's a teaser, right? You get all this money for a relatively low amount of money, but the bet's almost impossible to win because you have to win multiple bets at the same time. Well, come to Georgia and be a plaintiff's attorney, because you can get double. And we're waiting for the triple. We're waiting for the triple because there's another attorney's fee statute that potentially comes into play. And so we're waiting for the triple, in which case 50 would be 110.
Yep.
So it's scary.
We have a situation like that somewhat now on a case with a 9/11/68 verdict. The trial verdict was $40,000, but the attorney fee claim is well over $100,000 on a $40,000 verdict on the actual claim. So.
And the Shakespearean tragedy is one final comment. The Shakespearean tragedy of Georgia's offer of judgment statute, that was part of a quote unquote pro-defense tort reform bill. But I guess the folks who wrote the bill didn't realize that in most tort actions, the plaintiff doesn't have any money, but the defendant who has an insurer who does. So that was left out.
Just a reminder to the audience as we go, you're welcome to go ahead and submit questions to the live Q&A for Rena and Jay to answer throughout the webinar. And then Jay, how are these tactics impacting the staff of the carriers that you work with?
Impacting the staff?
Yes.
Well, I would say it's definitely leading, just as anecdotal. I'm not referring to any particular client or company, but just anecdotally, you're having a lot of good folks leave the insurance industry on the claim side, because that's not what anybody signed up for. I do an in-house, which I've done with Rena's company, Southern General, and a lot of others. I do an in-house seminar where I start out when talking about time demands and extra-contractual liability. And I start out with, I don't mean to scare everybody, but understand that the difference between a $33,000 fee and a $3,300,000 fee for the attorney sending you this demand on a really bad case with low limits, the difference between 30 and 3 million is you messing up. And that's just the brutal facts. I mean, the we can talk about a parlay. We can turn 30 into 3 million if I make you mess up in your job. If I'm the plaintiff's attorney, and I don't care what ramifications that has to you and your family. I don't care if you lose your job. Okay. But I want to make you mess up. And so I think that, once again, anecdotally, there's no question. I think that a lot of good, experienced folks are leaving the claims side of the insurance industry just because they don't want to deal with that. They don't want to deal with it. And ultimately here, and once again, I can't speak for other states, but ultimately, in Georgia, insurers will vote with their feet, as they say, if things get bad enough. And I surely hope they don't, because that's how I make my livelihood. But I think ultimately, that's the end game. Is it will be cost prohibitive to do business in Georgia. It will be cost prohibitive to do. I mean, I know that's a bit extreme, but and we're not there today, but certainly that is, that's where this is headed now. And Stacey, I may be getting a little bit ahead of myself, so cut me off if I am, because I know I feel like all we talked about is gloom and doom, so to speak. But I do think there are some common sense ways to handle this type of what I call a nuclear setup demand. And I would say the biggest thing for those of you participating today, and I'm not sure if you're at the claim handler level or at a management level, and it really doesn't matter. It really doesn't matter. The biggest mistake that I see made is the claim rep went at it alone when he or she got the demand. Mistake number one, it was the demand. They didn't know, they hadn't had the experience or the training to recognize, whoa, this looks strange. Maybe I need to talk to somebody. So I have a client that insurance client that refers to it as the boat. So if I had one piece of advice for everybody today, is if one of these demands comes in, and one thing I will say, they are fairly recognizable. They are fairly recognizable. And first thing, before you ever get it, you ought to be on alert, going back to the evil triumvirate, catastrophic damages, clear liability, and low policy limits. So if those things are present, at least if you're an insurer in Georgia, you're probably going to get one of these demands, is to train the claim representatives. Don't go it alone. Contact your manager immediately. And I know that that Rena's company has some excellent gold standard controls in place, as by way of ratio of medical expenses to policy limits, where there can't be a response or rejection or anything until a manager looks at it. And so I would say, from a claim handling, if there's any good news out there, it's get a bunch of people in the boat when these things come in. And if necessary, retain counsel. It's expensive, yes. I mean, and candidly, as an insurance consumer, you should not have to hire a lawyer to pay money, except under some very weird circumstances. But the reality of today, if you're in Georgia and where I am in Valdosta, I sit right on the Florida line. Same thing down there, although no question that Governor DeSantis' bill a couple of years ago has really made a big difference in Florida, which if you're in Florida, you know what I'm talking about. But in those two states, if you got a demand that fits this category of catastrophic damages and low limits, and I'm looking at something strange, my recommendation is to retain counsel, because it's way cheaper. It's way cheaper to hire an attorney to assist with the demand than it is to defend, first of all, the underlying case that's going to trial. When this thing blows and a counteroffer is declared, even if you prevail on the motion to enforce, you're going to spend a bunch of money. you're going to spend a bunch of money. And then if you don't, you're going to spend even more money. And then there's going to be an EC claim, and you'll have 2 or 3 attorneys on the meter, so to speak. So I would urge, the doctors say, never let the sun set on an abscess. And I think that is a valuable idea when dealing with these demands. Number one, get help. And number two, the human brain says, if it's difficult, put it on the bottom of the stack. I'll get to it tomorrow. On these demands, they need to be gotten to today. They are an abscess. They need to be gotten to today. And that way you can have time to get help. You can have time to get help.
We do have an audience question. If you had your druthers, what are the top 1 or 2 statutory or rule changes that you would propose to address your most significant concerns?
That's a great question. I'm laughing because I participated in 2 of the 3 versions of the statute in Georgia, 911-67.1, that was supposed to fix all of this. And I shouldn't be saying this since I was not the author. I'll make it clear. I want to share some blame. Okay. I want to share some blame. I was not the author, but I was an author of 2 of the 3 versions of that code section. And sometimes I think we just made it worse, because and so let me explain my answer. So you put in these protections. So some very, 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 very smart attorneys on the other side, they go through that statute like an English teacher would go through it, and they figure out ways to get around it. And so what the ultimate result, where you go back to 1991, is I demand your policy limits, and you got to pay me 10 days from the date of this letter. And, I probably mailed it a couple of days afterwards. You might have 24 hours, to accept it. We've gone from that, but it's a 1-paragraph letter. Now, literally some of the letters we've gotten, and y'all won't believe me unless you've seen one. You wouldn't believe it. With footnotes, 18 to 20 pages. 18 to 20 pages with footnotes. So that those letters, at least in part, are the result of an attempt by the General Assembly to limit these types of abuses. But to answer your question, I think the only way that you would ever stop it would be a very simple statute that says, if in response to a demand, the insurer tenders its policy limits in exchange for a release, and that can be done at any time prior to 30 days before trial. And if they do that, it doesn't matter whether they accept the demand or not. If you tender your policy limits in exchange for a release at least 30 days prior to trial, may not be a settlement, but there's not going to be a claim for negligent or bad faith claim handling against the insurer. And I would tell you that code section, we'd love to have it in Georgia, but we've not been able to get it yet.
Great. Thank you for answering the audience question. If anybody else has questions, feel free to go ahead and continue submitting those to the live Q&A. And then Rena, going back to the tactics that we mentioned earlier, how are these tactics impacting your team and your role at Insurance House?
Well, like Jay said, our rule is get somebody in your boat. So every demand that comes in is reviewed not by one set of eyes, but multiple. It starts with the adjuster, the manager reviews it, comes to me, the next level up. So there's never a demand accepted that we don't have multiple eyes on it. Advice I would give to everybody is to read that demand over and over and over. Read it when you get it. Read it when you're completing the evaluation. Read it when you're preparing to accept it. And if you're not prepared to accept it, then you get somebody else in your boat, like Jay Smith. That's another thing that we've had to do, is refer a lot of demands to him to accept, just to make sure that we cover ourselves and it's properly accepted. We refer a lot of those cases to him. And that 19-page demand he's talking about, we have that demand. We've seen it multiple times. And it is so contradictory. It definitely takes somebody with a law degree to read it and understand what they're asking for. to accept it properly. Time demands in Georgia have existed since not the early 90s, like Jay said, and started with a case that involved my company. So we certainly take that claim very serious. Every time demand is reviewed over and over. We have rules in place about the amount of specials involved that requires a roundtable of the file with not just the adjuster, but a whole team of folks, so that everybody's in the boat. Everybody's involved in that decision on to accept it or to reject it or how much to offer on a demand. So that's some of the things that we've had to do. We also had to adapt technology just to better identify demands. Insurance companies receive a lot of mail. So we have a computer system that is set up simply just to identify time demands, to recognize them, and to use AI to recognize them so that it's accounted for. We know when a demand is received. We know when it expires. We know that a week before it expires, 2 days before it expires, the day it expires, and God forbid if it ever expired without a response, we would know about it. Luckily, that's never happened, but that's pretty much it. And what I second what Jay said, that a lot of people are just wanting to be out of this business because it is just so dangerous and risky. Our companies, everybody's considering whether or not they want to stay writing business in the state of Georgia, or you want to try to move to another state that is not so volatile. So I think that more and more carriers are considering leaving this state because of the situation that we are in, and that's number one judicial hellhole is the reason. So,
can you tell me, Rena, how technology has played a role in managing this process?
Well, like I said, we have a computer system in place that identifies time demands. We get about 350,000 pages of demands per year, and it analyzes all that information and gives us daily records of demands that are received. It identifies them. And that definitely helps that we're not relying on a human eye to do that. It sets up a scheduling to respond to the demand, to make sure it's never missed. It manages, every aspect of it, from the time that it comes in through the evaluation process until it's settled and until it's closed out. So technology has definitely had a big impact on us. We've had that system in place since about 2019. And like I said, it reviews 350,000 pages of demands every year. And it saves us about, we estimate, 48% of time management by using it.
Thank you very much. Jay, where do you see the industry heading, and what is your advice for the claims professionals in the audience today?
Well, just to kind of go over something I've already said, but it's one of those things you can't say it enough, is to encourage your claims professionals. Do not go it alone. There's got to be, like I say, the mistakes I see made are. And by the way, that doesn't mean you're not going to make mistakes, and that doesn't mean the attorney's not going to make mistakes. It's difficult for attorneys to accept these demands, and we're not always right. We're not always right on it, but a collaborative effort, in my opinion, is essential, and it starts with training the frontline claim representatives. If these parameters are met, catastrophic damages, low limits, don't even talk about clear liability, just the first two, then there needs to be a heightened state of awareness. And if you get a demand in, by all means contact your manager immediately. And the best way to sell it is in my mind, just going by my background a long time ago, when I made an honest living, was in the textile industry. And my father always said that if the weaving department is running poorly, it's not the fault of the weaver, it's the fault of the department manager. And so the way I would sell it is, if to the frontline claim professionals is if you get this and you run it up the chain of command and something bad happens, it's not your fault. I mean, it's to me an easy sell instead of it being red tape and why do I have to do this? Hey, it's exculpatory. If something goes south, it's not going to be your fault. And I know it's kind of an ugly way to put it, but I think it is a motivator. It is a motivator to the frontline claim professionals. Get help. And if you don't care about any other reason that you need to get help, you don't care about the company, you don't care about anything, care about yourself. Care about yourself, because this will help you. This will help you. And I really think that it, plus the technology that Rena is talking about, those two things, they will certainly not eliminate mistakes, but they will absolutely minimize mistakes. And that's really all you can ask for in this day and age, is because, hey, y'all in the insurance industry, if you save money on 10 claims and then you have a bad one, well, you protected yourself because you saved money on 10. And, if you do 10 time demands correctly, and then here comes one that's for whatever reason mishandled, at least you save money on these other 10. And I just think, it shouldn't be that way, by the way. That should not be the way it is. But that's the current way it is. But I do think, I know there's some things going on in Georgia beyond what was done in the last session of the Georgia General Assembly. I know that our governor has an awareness because of, do you want to do business in Georgia? It's not just, hey, if some type of industry wants to move into Georgia, but they can't get liability insurance, or the liability insurance is astronomical, they're not coming. They're not coming. And I think that idea is making tremendous gains in awareness. So I think that Georgia is at a pivot point from what I've seen, but I at least am hopeful between what the industry itself is doing, plus things that are going on public policy wise. I'm at least hopeful that we can see light at the end of the tunnel.
Thank you so much for that. If you have any questions for Rena or Jay, if you could go ahead and submit those to the live Q&A. Additionally, Rena and Jay have both shared their email address if you have any questions for them. Let me just check for questions one last time. It doesn't appear that we have any more questions, so let's go over a few reminders before wrapping up today. To view a recording of today's webinar, simply return to this webinar portal and locate today's session on the timeline. There, you'll find a link to the recording. Should you encounter any difficulties accessing this or any other webinar recordings, feel free to reach out to events@namic.org. Keep in mind, webinar recordings will be available 48 hours after the live session. NAMIC is offering a variety of upcoming in-person and virtual events. For more information, please visit www.namic.org/edu/calendar. And as you exit the session today, a survey will pop up. We would greatly value your feedback and encourage you to spend a moment to complete it. Rena and Jay, we want to thank both of you for sharing your expertise with us today. Have a great afternoon, everyone.
Thank you very much.
Thank you.